when you look at the grand scheme of things, when you're looking at misdemeanors, because this is what we're talking about, misdemeanors. We're not talking felonies. Most of your cases are going to be DWIs, assaults, whether they're family members or theft cases on it. You're not going to have, in a docket of 72 people, you're going to have maybe 4 or 5 people that are charged with marijuana on it. So I know that friends of mine that are bondsmen don't like that, because that's cutting into their revenue of being able to bond somebody out. And I don't know if you want to transition into the bail schedule onto that. But
Juan, giving us segues.
Go, bring it in, Juan. Bring it in.
First time on the show.
Bail bondsmen that they're friends of mine that are talking about, I don't like that they're having to do all the pretrial bonds because that cuts into my funds. I don't like that they're not going to be charging and arresting people. That cuts into my business on it. And so, I mean, it goes both ways on that.
And let's not pretend that they don't have influence, because they do. It is a big money-making machine. From a defensive standpoint, from a defense attorney standpoint, though, what happens is that, and I've said this many, many times, nobody knows the value of a day until they spent 24 hours behind bars. The longer your client sits in the cage, the more likely he is to sign something that he really shouldn't be signing. The more likely he is to get pressured into a plea bargain that he really shouldn't. And oftentimes, if it's a very defensible case, it's a good case to go to trial. But if the guy can't get out, he's going to sit in jail until the time of trial, which could be 3 months from now, 4 months from now. And I can't tell you how many times I've run across clients who just say, look, I just want to go home. I just want to get out of here. Just let me sign. And it's heartbreaking.